Let me tell you something. We had a lawyer who was called Bob Kasango. Was a very brilliant lawyer, very brilliant. The way you see his counsel Semakade is brilliant. Like, you can discredit every other thing, but when it comes to the head, they are there. So Kasango was a lawyer almost with no border, very brilliant, but he had cases of corruption against him. Corruption, and of course, so many people were crying against him. At one point, he was convicted to receive, I think, 16 years in prison. So Kasango is so important in the current state because Kasango in 2016 filed a case to the Constitutional Court against the appointment of the DPP, that was Justice Mike Chibita. Mike Chibita was the DPP who was leading a prosecution against Kasango, Bob Kasango. So Bob Kasango filed a case to the Constitutional Court, and his reasons were: one, the appointment of a judge from the High Court to be the chief prosecutor of government as the DPP. Number one, causes a fusion of the two arms of government, the judiciary and the executive, which is against the constitution that provides for the separation of powers. We have the doctrine of separation of powers. Number two, when you are a judge and or whoever is in the office of the DPP, you will advocate for and work everything at the interest of the executive. So you can't put someone there who is still a judge at the High Court to do that because he belongs to the judiciary. Now you've put him as the executive. That is fusion of the two arms of government. So he wanted court to declare the DPP's appointment, Mikey's appointment, null and void, and everything he was doing in his office to be invalid, null and void, including the investigations they were doing on him to be dropped because they were null and void. That was Kasango's reasons, which were of course valid. So later on, court in 2021 delivered a ruling. The ruling that court delivered, number one, court said that any judge who is to be appointed to any office of the executive or the constitutional offices must first of all resign from being a judge. Then you can take up those appointments. But if you don't resign, you go ahead and go to those offices and perform duties. Number one, your appointment is illegal, unconstitutional, null and void, and everything you will be doing in that office is null and void. So you find that that judgment is a very powerful judgment because we have judges that are in executive offices, in constitutional offices, because those the major two would be Justice Biabakama in the as the chairperson of the Electoral Commission. So he had to resign by the court order. Then we also had at the time of the ruling, we had the Justice Abodo, Jane Abodo, who was the DPP in 2021. So Jane Abodo, first of all, resigned. I should say she stepped aside after the court ruling because court had said whatever she was doing in her office was illegal, unconstitutional, null and void, including her appointment was null and void. And so also Biabakama had to do the same thing. But of course, worry would be that what about the 2021 election that was run by Justice Biabakama? Of course, the laws work forward. So according to the ruling, whatever they did before is okay. But whatever from the day of the ruling forward, no judge should accept to be into an office of an executive wing, constitutional office before resigning. So that was the court ruling. Of course, Kasango was rewarded, though he had passed on by then. Unfortunately, he passed on from Luzira prisons, and It was unfortunate because he passed on as a result of our judicial failure, because he made several attempts to the judiciary to allow him go and see his doctors, even despite specialists recommending that he needed urgent and critical care. uh, the judicial system failed us, and he passed on. He passed on as a result of heart failure from Luzira prisons. So it was unfortunate. During the time of the court ruling, he had already passed on, though he was rewarded. The reward was because there was already a previous ruling. The previous ruling was about the IGG. We had Justice Faith acting as the IGG back then, and Justice Faith's appointment was also challenged in court. That was by the other group of Mike Mukula, if you recall, that group that was involved in corruption cases. So the DPP who was leading the prosecution against them was Justice Faith. So they challenged Justice Faith's appointment, her activities, that the appointment was illegal, null and void. So everything she was doing in her office was null and void. They wanted court to drop everything, to make an order to drop everything. Of course, court made a ruling that Justice Joyce was still a judge of the High Court. So appointing her as the IGG, which is directly under the executive, was illegal, unconstitutional, null and void, and everything she was doing was null and void in that office. But then, of course, the investigations she had done with the other teams against that group wasn't cancelled, because court reasoned that there were other people who were in that under the office of IGG legally. So she didn't do the investigations alone. So whatever was investigated against them went on. Even the case against them went on. So because there was already a previous ruling that you can't get a judge and put in executive office or constitutional office before them resigning, Kasango was rewarded. So what is people's cry against Jane Abodo? Jane Abodo, after the court ruling, she stepped aside temporarily. But after some times, she was reinstated in office. Of course, now that is illegally. And I think their reason was that the absence of a DPP would cause a constitutional crisis, that we wouldn't have prosecutions going on as they should be, because there would be no head. I think that was their reasoning. But in any other way, they brought her back in that office illegally. So that is Justice Abodo. So Abodo had to go back and resign from being a judge, and then come back and take on the role of a DPP. But she didn't do that. And all of them don't do that, because we have so many judges that are working under the executive and in the offices of the under a constitutional office. I think they fear resigning from being judges, because these offices you get appointed to. So tomorrow the executive might change up their mind and appoint another person. I think that is their fear, that you may lose your jobs from everywhere. But from that 2021 court ruling, whoever is there and you're a judge and you're in the offices of executive, constitutional offices, performing duties, you're there illegally, unconstitutionally, and everything you're doing there is considered null and void. 2026 elections, when it reaches and Byabakama has never resigned from being a judge, and then he organizes elections and all that, the law is saying that he is not supposed to be there without resigning, and if he insists whatever he will be doing there is null and void. So that is what people are crying against Jane Abodo, that you number one, you're in that office illegally, even against constitutional court ruling. Number two, there are people who are being sent to prisons when they shouldn't be sent. There are cases you prosecutors are putting on people that really represent a constitutional crisis in this country. We had cases of Ida and disorder, like those cases. Then we have a lot of people who are in prison when they should not be there. Those are people's cries against Abodo. And when Counsel Semakade spoke about it, then we saw a lot of people issuing statements, a lot of people demanding him to apologize. Of today, we saw even, is it the parliamentary group from the side of Karamoja coming out to say he has to apologize, which is really laughable because when you look at the groups, you look at the female lawyers, is it network? We have had female Ugandans being persecuted. We had the likes of Dr. Stella Nyanzi, who was persecuted severely in Uganda. We never saw this group coming up to speak anything or condemn anything about it. We have had Justice Chisache during the 2021 election petition. That lady was highly persecuted in broad daylight. We didn't see the female lawyers network coming up to say anything. They didn't stand with her. So they can't come up now because whatever Semakade is saying is protected by the constitution. Then we are seeing the group from Karamoja, the parliamentary group from Karamoja. If you ask what did they say about the iron sheets that were stolen, that were meant for the Karamoja people, I don't recall what they said. I don't recall their involvement because I personally didn't see them. There was a period where the Karamojongs or people in Karamoja sub-regions were being killed. It made a lot of news. We didn't see them coming up with this kind of protest to demand for accountability from government, public apology. We didn't see them. We normally don't see them doing that. There was a period where cattle from Karamoja were being stolen in large numbers. We have not seen them actually say anything about it. So when they want to pick up this and then begin using it, I feel like they are self seekers and they don't have any basis. Now, another thing about the DPP, the recent one is about Dr. Kizza Besigye, because now the DPP has now been part of the people who have abducted Dr. Kizza Besigye from Kenya, a place where they have no jurisdiction, and now they are prosecuting him. That is really, really, really highly illegal. So I expect these people who are condemning this should focus their energy on the illegalities of the DPP and all other irregularities, champion for the rule of law. Because when you look at freedom of speech, there's a case ruling. There's a case. We have the case of, actually, let me get it for you. Why should I struggle so much? We have the freedom of speech and thought expression. You see, there was a case of Charles Onyango. This was Charles Onyango Obo and Andrew Mujuni Mwenda versus the Attorney General of the Republic of Uganda. And I believe they are aware about this, because if us who are non-lawyers have a clue about it, the crime was freedom of expression. So I want to give you a brief thing about it. So the summary of the ruling, the legal issue was, number one, whether limitations of freedom of thought, conscience and the press imposed by the offense of publishing false news under Section 50 of the Penal Code Act is justifiable in a free and democratic society within the meaning of Article 43 of the Constitution. Because Article 43 of the Constitution, it has a title of general limitations to the freedom of speech, thought and expression. Number two, whether Section 50 of the Penal Code Act clearly defines the offense of publishing false news and its penalty in the meaning of Article 28(12) of the Constitution of the Republic of Uganda, that's 1995. So there was a court ruling about it, and I'm going to be very fast about it. Court declared that Section 50 fails the test laid down in Clause 2C of Article 43 of the Constitution, in as far as the limitation it imposes on the rights to freedom of speech, expression, as well as freedom of press and other media expression is not justifiable in a free and democratic society, and therefore struck it down. So it struck down this provision. It also found that the offense and penalty, the offense and penalty of publishing false news under Section 50 were not clearly defined as required by Article 2812. The court held that the freedom of expression guaranteed under Article 29 of the Constitution extended to expression or publication of false news. It rejected the contention that the extension of the constitutional protection of freedom of expression to cover false statement is incompatible with upholding truth. It instead stated that scrutiny of the limitation of the enjoyment of right under Article 43 did not lend any support to the proposition that the protection excludes false expression. The court further found that in the circumstance of a conflict in constitutional provisions, wherein there are provisions in the Constitution for both protection and limitation of rights, the court is under the duty to resolve the conflict, having in mind the different objectives of the Constitution. And in doing this, it should take guaranteed rights as the primary objectives of the Constitution. And the reasoning of the court was like this. The Supreme Court reasoned that limiting the enjoyment of freedom is an exception to their protection and therefore a secondary objective. Although the Constitution provides for both, it is obvious that the primary objective must be dominant. It can be overridden only in the exceptional circumstances that give rise to that secondary objective. In that eventuality, only minimal impairment of enjoyment of the rights strictly warranted by the exceptional circumstances is permissible. The exceptional circumstances set out in Clause 1 of Article 43 are the prejudice or the violation of protected rights of others and prejudice or breach of social values, categorized as public interest. So, in summary, for us the non-lawyers, freedom of speech, expression, and thought that is not only limited to when someone is giving you praises. Someone can insult you, they have that right. Someone can speak vulgar against you, they have that right. In fact, the Constitution even says that the protection of freedom of speech, thought, and expression is even more important when what the person has said or done is viewed by the society as negative. That if I'm doing a negative criticism that the public is viewing as negative, that is where actually the protection for my right of freedom of speech, expression, and thought should even be considered as more important. So, in conclusion, anyone can insult anyone as long as you're in a democratic society, because under democracy, practically when someone says something negative, you can only counter them with something positive. Under democracy, you're supposed to coexist. You're not supposed to only live with the people that love you, praise you. You're supposed to live with those that are even negative and against you. In fact, those ones, even the protection for their freedom of expression, rights, and thought is expressed as being more important. So anyone can say anything against you, and whatever Semakade say is protected by the Constitution, and the lawyers know it. The only thing is they want to mislead the public and act as though they are doing something. What they forget is that Semakade won this election by a very high margin. It was a protest vote, and people did not vote Semakade there to demonstrate decorum, because we know him. The lawyers voted Semakade there to do whatever he's doing, and he has done it well. Maybe the only thing where some people have cry with him is he visited the Chief Justice. Semakade visiting the Chief Justice and then him complaining about the DPP's illegality and unconstitutional presence as while still a judge in the High Court is understandable, but he had to visit the Chief Justice. He's a leader. He had to do that. But beyond that, whatever Semakade is doing is okay.
And the few lawyers who are making noise here and then, they are fighting him from day one. It is not proper. He won by a very high margin. It was a protest vote. Allow the man to work. Give the man his chance to work. If people wanted decorum, they would have voted for you, but they didn't opt for that. They did not opt for that. Semakad is radical. You see, there's being radical, but within the law. You're radical, non-violent. You're radical, very lawful. You need to stop being that childish, because you need to realize that the Uganda Law Society is not working for only lawyers. As the outsiders, you are working for us. And when you notice that right now, majority of non-lawyers are very concerned and they are taking interest in the lawyers in the country, the Uganda Law Society, the judiciary, the courts, the prisons, you need to read what is happening in the country. People are so much interested because there's a lot of impunity, a lot of illegality that is happening, and they happen under your watch, you the decorum people. So you will, if you still think that the world is not changing, look well, there's a revolution that is happening, and the people who are in suits disappointed people a lot, and you will see a lot of people who don't align with that, being in suits, dressed very smart, talking on very low tone, because you have demonstrated a failure for very many generations, and the world is tired. So allow Semakade do his work, because whatever he's doing it within the law. Leave him to be radical as he is. That's why people voted for him. People knew Semakade. People have not seen him today. People know him. Semakade, even you see, I still believe that Semakade, even visiting the Chief Justice, does not stop him from doing what he has to do. Because the Semakade we know, you can laugh with him now, and he tells you truth to your face when there's something he needs to be done right. So allow the man work. Stop. You're all looking so petty now. Everything Uganda Law Society is doing, you are against. You don't even realize that Uganda Law Society right now is so popular than in your time. In the times where we had people of decorum, they failed us a lot. Actually, majority of us used to got to know about Law Society from Kenya, because those ones work. Ours here, we actually didn't know they exist. Some of us went there and we got disappointment. So allow people to work when they're in those offices. Don't fight. Now you're pushing for impeachment. Impeachment where someone was elected by that high margin majority. You need to be ashamed. You see, you can do all the organization against the man, but kindly allow him do his work. If the people, he said that vagina from Karamoja, and we are all shouting. The question is, are you ashamed of the genitals, the genitalia that he mentioned, or are you ashamed of the district of origin? What is your cry about? Let us focus on the illegalities, irregularities of the DPP's office. That is the main issue, because you have all been knowing about it. Even as the non-lawyers, we have been watching, and you have been doing nothing. And I think the last thing I want to talk about is government trying civilians in military court. The lawyers, the decorum lawyers, know that there is a court ruling that is against that. Until of recent, Agora, Atuhaire Agatha and Agora team filed a petition, I think, to the Supreme Court, because there's already a court ruling and the current Chief Justice is sitting on it. They don't want to give a ruling to people, and the current Attorney General, they have failed Ugandans, because we are seeing civilians being tried in military court, the court martial. So all these people who are shouting at Semakade, DPP, that should be your main focus, because if all along you have been knowing and you have kept quiet as lawyers, that is your responsibility. That is your responsibility, that you needed to put that pressure. You allowed civilians to be tried in military court, and now you're talking. It is really, it is, I don't know how I can describe you, but You need to pull up your socks. You need to style up and stop that petty fight you're trying to pull out. You stop it. Focus. There's a lot of things to change under this system, especially the judiciary, because I think the judiciary is what people are seeing as the last hope. And I think the executive has realized that, because of recent, I saw President Museveni saying that Uganda does not belong to judges and courts. Meaning he has also realized that majority of Ugandans are turning to the judiciary as the last resort to be saved. So you need to style up. We are tired of putting on those suits and just looking good and doing nothing for the people of Uganda. Allow Semakade to work. The DPP, you're a judge, and then you took an oath, you took the judicial oath, but you're the ones breaking the constitution, you're stepping on it. So there's a lot of impunity that happens in this country, and it is worrying.